Yes, hello guys. Dito pa rin tayo sa exception to the privilege of section 11. Sa 9, 10, 11. Nandun na tayo sa 9, 10, 11. Sunod na ito. There is no privilege under the section 9 if a court of administrative agency finds, after a hearing in camera, that the party seeking discovery of the proponent of the evidence has shown that the evidence is not otherwise available, that there is a need for the evidence that substantially outweighs the interest in protecting confidentiality and the mediation communication suit or OFA. And guys, dito sa exception of privilege in section 11, according dito sa B, meron doon mga ebidensya na hindi talaga, na hindi inilalagay o hindi kagad na di-discover during the process of mediation process. But otherwise guys, nagkakaroon ng supporting evidence of substantial evidence na nagpapatunay yung isang ebidensya ay kailangan ilabas, di ba? Hindi lang confidentiality ang pinag-uusapan guys, but yun, dito kasi sa exception to privilege, yung privilege na tinatawag natin kanina, ay pinaprotektahan natin yung confidentiality ng isang information. Pero, kung ito'y makakatulong guys regarding the involvement of the crime that committed of a person, lalo na kung ito talaga ito yung susi para magbukas yung kaso, kailangan ilabas to, di ba? Kasi ito yung magiging substantial evidence na tutulong upang matuloy yung kaso. Ito, 1. A court proceeding involving a crime or felony, or a proceeding to prove a claim or defense that under the law is sufficient to reform or avoid liability on contract arising of the mediation. Ibig sabihin guys, kung ito'y malalaking kaso, lalo na kung ito'y involving sa mga pagpatay, pagnanakaw, mga malalaking mga business sector, lalo na kung ito'y nilabag sa felony na tinatawag natin sa felony, di ba? Yung mga felony na kaso natin is the special penal law, di ba? Offense ba o felony? Correct me if I'm wrong. Yan, a proceeding to yan. Para mag-proceed yung isang kaso, kailangan ilabas yung confidentiality ng information to support the supporting evidence na magpapatunay o magbubukas ng pinto upang makuha kung sino talagang gumawa ng kasalanan na yun. Di ba? Yan. A mediator may not be compelled to provide evidence of mediation communication or testify in such proceeding. Si mediator guys, hindi pwede niyang i-compel yung mag-provide ng evidence during the mediation communication. Si mediator kasi guys, ano lang talaga siya. Nandun lang siya, papagitna lang siya. Kaya, yun. Titignan niya yung ibibigay sa kanya ebidensya, tsaka niya lang ito itatanggapin o hindi, disapprove o approve. Pero meron tayong mga jury, meron tayong other branch na magtitingin talaga kung ito yung approve. Pero karaniwan, si mediator, yan. Siya talaga yung nagde-decide din, di ba? Pero in terms of the mediation communication, hindi niya pwedeng magbigay ng payo ng basta-basta ng ganun. Kasi parang magbigay siya ng, parang magiging bias, di ba? If a mediation communication is not privileged under the an exception in subsection or A or B, yung kanina guys, there is no privilege against disclosure under the section 9 if mediation communications. Sa mediation communication na kaso, di ba? Kasi dito sa C, hindi pwede magbigay ng mediation communication o magbigay ng kahit anong information regarding the case sa ang mediator kasi magiging bias ng kaso. Dito, only portion of the communication necessary for the application of the exemption for the non-inclusion may be admitted. The admission of particular evidence for the limited purpose of exemption does not render the evidence or any other mediation communication admissible for any other purpose. Yan guys. Pwede maglabas ng mga ebidensya regarding the mediation communication of the continuous processing of yung process ng mediation process. Pwede, pero other purpose na yun. Pwedeng ipasok sa ibang purpose na evidence. Pwede nilang ilagay kung saan man ito yung dapat ilagay para maging sapat na ebidensya regarding the case itself. Section 12. Prohibited mediator reports. A mediator may not make a report, assessment, evaluation, recommendation, finding, or other communication regarding a mediation to a court. or agency other authority that make a ruling or dispute that is the subject of a mediation, except where the mediation occurred or has terminated or where a settlement was reached, as permitted to the disclosed under the section 13 of this chapter. During the process, yung mediator, hindi pwede siyang maglabas ng kahit anong report, assessment, evaluation, or recommendation, findings, ongoing mediation process, di ba? Hindi niya pwedeng ilagay ito. Kasi kapag gano'n, parang nilabas mo kaagad kung sinong may kasalanan. Pero mayroon exception, where the mediation occurred or has terminated. Ibig sabihin, natapos na or na-terminate yung ongoing cases, di ba? O nagkaroon ng settlement during the both parties, as permitted to the disclosed under section 13 of this chapter. Dito sa section 13, lumabas na nagkaroon ng disclosure o nagkaroon ng maayos na usapan dun sa magkalaban. Yan, section 13, disclosure and conflict of interest. Yes. Before accepting a mediation, an individual who is requested to self-mediator shall, kung ang isang bago magsimula ang mediation process or individual mediation na tinatawag natin, pwede silang mag-request dun sa mediator na kung ano. Ito ba? Ito yun guys. Make an inquiry that is reasonable under the circumstances to determine whether there are any known fact that a reasonable individual would consider likely to affect the impartiality of the mediator, including financial or personal interest in the outcome of the mediation, and any existing or past relationship with party or foreseeable participant in the mediation. Ibig sabihin guys, si mediation, yung before mag-start na mediation process, pwede kayo mag-request kay mediator o mag-inquire kay mediator kung ano ba yung mga fact or reasonable effect kapag pag nag-move forward na yung kaso na tinatawag natin. Diba? Pwede kayo yan. Magkano ba magagastos dito? Sa tingin niyo po ba? Tama po ba yung ginawa ko? Mga ganun ba? Pwede kayong hindi ng advice, kumbaga. Disclosure to the mediation parties, any such fact known or learned as soon as practical before accepting mediation. And guys, dapat magkaroon muna kayo ng disclosure both parties. Mag-usap muna kayo. Kung kayang i-settlement nyo na kagad. Diba? Parang hindi na pumunta dun sa malalim na usapan. Pero kung hindi magkasundo, yan. Magkakaroon kayo ng practical, magkakaroon kayo ng learned process na tinatawag para malaman kung ano yung ongoing mediation na magaganap kapag hindi kayo nagkasundo sa mga bagay-bagay. Diba? Yan. If a mediation learned any fact described in paragraph A or 1 of this section after accepting a mediation, the mediator shall disclose it soon as practicable. At the request of mediation party, an individual who is requested to serve as mediator shall disclose her qualification to mediate a dispute. Yan guys. Before mag-start yung mediation process na tinatawag natin, yung pumapagitna o papagitna, hindi lang kasi judge ang pumapagitna yan guys, di ba? Merong mga taong pumapagitna. Ibig sabihin, hindi lang judges, pwedeng barangay tanod, barangay chairman, o other mga babang hukuman. Pwede yan guys. O kaya meron lang kayong mga hindi pagkakaunawaan. Gusto nyo lang magkaroon ng mediator sa isa't isa nyo. Diba? Kaya nga meron tayong ADR provider. Diba? Alternative Dispute Resolution na kung saan nagbibigay daan upang kung sino man o kung meron kayong hindi pagkakaunawaan ay masolusyonan nyo sa tamang pamamaraan. Hindi na umabot sa Korte Suprema, kumbaga. Itong mediator guys, ayan, kailangan tinitingnan muna natin o tinitingnan muna nila kung karapat-dapat bang itong mediator na to na pumagitna sa kanila. This act does not require that a mediator shall have a special qualification by background or profession unless the special qualification of a mediator are required in the mediation agreement or by the mediation parties. Yan guys, dito sa mediator, hindi naman kailangan maganda o magkaroon siya ng special background na talagang siya ay ito kanyang trabaho, di ba? Unless na magkasundo yung both parties na ito, pwede talaga maging mediator ito kasi alam niya yung trabaho niya. Like I said guys, yung mediator natin, yung mga pinauna ko lang sa inyo, hindi lang judges ang pwedeng maging mediator. Ibig sabihin doon, ay merong mga bagay na pwede kayo mag-hire ng mediator sa mga hindi nyo pagkakaunawaan to disclose any information, di ba? Pero kailangan, alam nyo kung yung mediator na yun, karapat dapat na pumagitna sa inyo. Kung hindi kayo, kung alanganin kayo, pwede kayo mag-hire ulit ng iba. Section 14, Participation in Mediation. except as otherwise provided in the Act, a party may designate a lawyer or any other person to provide assistance in the mediation. Yan guys, sa Section 14, Participation in Mediation, in any case na hindi mo maintindihan o meron kang hindi maunawaan regarding your cases, pwede ka mag-hire ng lawyer kung may mga private lawyer, karaniwang private lawyer talaga, na nag-hire sila upang maintindihan nila ng gusto yung kaso na gaganap. Diba? A lawyer of this right shall be made in writing by the party waiving it. Yan. Dapat sa yung lawyer ay dapat talaga ay ito yung karapatan na binibigay sa isang tao upang ang writing na yun guys ay magsimula ng totoo, di ba? Yan. A lawyer of this right shall be made in writing by the party waiving it. A waiver of participation or legal representation may be resigned at any